The case I chose was Sherman versus Mamaroneck Union Free School District. The opponents in this case were Eleanor Sherman, Armin Nishanen, and their son Grant Nishanen on one side. On the other was the Mamaroneck Union School District, represented by Sherry King, their superintendent, Michael Louisi, their 5-4 coordinator, Mark Orfinger, the high school principal, Ann Garcia, the unit principal, Dr. Jane Friedlander, and the Mamaroneck Union Free School Board. The critical facts of this case were that before starting high school, Grant, an individual classified as learning disabled due to a disorder that affects his ability in mathematics, had an IEP drafted that included the use of assisted technology to help him in math. One of these was the Texas Instrument Model 82, or the TI-82 graphing calculator that can be linked to a computer, which was used by Grant for the first 2 years of his high school career. For his junior year, his IEP still included the use of a graphing calculator, but did not name a specific model to be used. Grant's mothers asked for him to be able to use the TI-92 for his upcoming math class, which the school said they would let Grant's teachers decide if the TI-92 was appropriate to use during tests. Grant's parents received his junior year IEP to sign off on and did so, only stating issues with aspects other than his math class. And when the school year started, no official word from the school had been given on permission to have Grant use the TI-92. The parents took the non-response from the school's permission, and Grant started using the TI-92 for the first 3 weeks or so of his new 3A math class. Once his teacher realized what calculator he had been using, even on tests, she and the school asked Grant to retake tests using the TI-82 and would be allowed to use the TI-92 to check his answers, to which Grant's parents rejected, causing Grant to receive an incomplete in his math class for the first marking period. The teachers and school's reasoning are that the purpose of the 3A math class is to have students gain the ability to show the steps they followed in finding their answer. The TI-92 will give the right answer, but it does not require the user to go through the steps to arrive at that answer, while the TI-82 does just that. Grant's teachers all agreed that Grant had the ability to factor and was able to do the necessary steps with the aid of the TI-82. It was determined that it was educationally beneficial for Grant to acquire new skills, like learning how to factor, and it was well in his ability to learn how to do so, making the TI-92 in the school's eyes inappropriate to let him use during tests. Grant and his parents met with representatives from the district, and a plan was put in place to let Grant take alternative assessments dealing with content for the first marking period using the TI-82, but Grant never turned in the assignments. At this point, Grant and his parents formally asked for a hearing, claiming the school was discriminating against Grant based on his disability, and IDEA hearings were held between the months of January to March of 1999. During these hearings, it was decided that the school was not discriminating by restricting Grant's use of the TI-92, that Grant was able to perform the skills asked of him with the TI-82, and that Grant was willingly not doing work as a means of protest. It was even admitted by Grant himself during evaluations by an independent party that he was able to do the work required with the TI-82 and demonstrated the ability to do the work asked of him. It was decided that Grant's junior year IEP was reasonable, and the school fulfilled their obligations for the IDEA by supplying Grant with a TI-82. Grant and his parents, unsatisfied with this outcome, brought the school district before the district court, where the court ended up siding with Grant and his parents, claiming that the purpose of the IEP was to have a student be successful, and seeing as Grant was passing his class with the use of the TI-82 and only began failing once it was taken away from him, despite the school showing that he was able to do work just fine with the TI-82, that the school was in fact discriminating, and the court had the school pay damages and lawyer fees to the family. The school appealed to the United States Court of Appeals, Second Circuit, but only to the effect of the IDEA claim with regard to the use of the TI-92. The systematic issues of the law were whether the school, by denying Grant the use of the TI-92, was non-compliant with IDEA and not offering Grant a free and appropriate education or faith. The court was to decide if the IEP was appropriate and that the school was attempting to provide Grant with a meaningful education. The court decided that after reviewing the information from the district court trial, they decided in favor of the school and it was justified in restricting the use of the TI-92. The reasoning behind this decision was that while the student earning failing grades in most circumstances would show a denial in educational benefit, IDEA does not state that a school must pass a student when they fail even though they are proven able to succeed with the accommodations provided to them. With the findings of the initial evaluations done by independent parties and the admission from Grant himself that he was able to do what was asked of him with the TI-82 with no issues, it was determined that the school had acted in accordance with IDEA and supplied ample opportunity for Grant to succeed. There were no opposing opinions as this was not a Supreme Court case. The implications of the verdict are not as obvious as other cases, but just as important. By having the court side with the school that was doing everything that right, and generally have the best interest of the student in mind, it empowers other schools to do the same and not feel threatened by parents that just want the easy solution for their children. While it's obviously important to have parents' input on how their child is being educated, there are situations where the wishes of the parents are detrimental to the education of their child, and they just don't realize it. By backing a school that was both supporting a disabled student effectively and giving them a meaningful and appropriate education, it lets other schools know that it's okay to disagree with the parent. This also brings a more defined meaning to the role of assistive technology when referencing IDEA. Assistive technology should be doing just that, assisting the student, not just giving them the answers. It'll help the student reach the end goal, but still give an opportunity for the student to learn and expand on their understanding of a concept. It should be stated, though, that the school might have been able to avoid a lot of this confrontation if they had been given a definitive answer on Grant's use of the TI-92 before the school year had started, with his family had first asked. I hope this was informative. Thank you very much.